What's up, everybody? Welcome back into another episode of The Lawyer You Know, and we are diving back in to the Baldoni v. Lively et al. Case. And we're going to look at Blake Lively's motion to dismiss. It's actually a very good bit of lawyering, but does it have teeth? Should Baldoni and his team be worried? You know they're going to respond. Both sides have been filing motions back and forth, but in this video, we are focusing on the motion to dismiss. There's snark in it, but there's also some very good legal arguments made that could be a pretty big hurdle for Baldoni to get over in his defamation lawsuit, specifically against Blake Lively. So this motion to dismiss was filed last week, and it hits all of the different causes of action. And some of them is just kind of conclusory statements as far as, there's a failure to state a cause of action, or it's a failure to simply follow the pleading requirements. Therefore, it should be dismissed. And anything that gets dismissed for those reasons will be dismissed without prejudice, which means Justin Baldoni and his team will be able to refile those causes of action in another amended complaint. So those are less important for our legal analysis. So we're really going to focus in on the beginning, kind of the first half of this motion to dismiss. The first 4 pages that we read, which is kind of the summary of the argument, is the most exciting, snarky, and important part to let us know where they're going. And then we're going to dig into some of the legal specifics throughout the video today. It won't be an incredibly long one because I really want to get at some of the meat of this motion and what's most important for where Blake Lively and her team are going to try and specifically attack Justin Baldoni's defamation lawsuit. And you'll hear how they talk about the harassment charges and what she says and what she claims, because this is not proving those causes of action. It's very different proving civil causes of action versus defending them. And that's important to keep our mindset right as we read through this motion to dismiss. So let's get to page 1 after we get past the whole table of contents. Here we go. Introduction and summary of the argument. The Wayfarer party's vengeful and rambling lawsuit against Blake Lively is a profound abuse of the legal process that has no place in federal court. The law prohibits weaponizing defamation lawsuits like this one to retaliate against individuals who have filed legal claims or have publicly spoken about harassment and retaliation. The right to seek legal recess and the right of the press to report on it are sacred principles that are protected by multiple privileges, including the litigation and fair report privilege, which are absolute. And guess what? She is right. And I'm going to give some parallels between the Johnny Depp Amber Heard case and this during this motion to dismiss, because what I'm thinking in my head is a lot of these arguments Blake Lively is making, right? It seems like in these cases, the public started with Amber Heard, ended up generally with Johnny Depp. It started with Blake Lively. It feels like momentum has moved in Baldoni's camp. But legally speaking, if you stick to certain legal principles, like it's an absolute right to say and do certain things, that is better than trying to prove what you said is absolutely true or horrible things that the defendant has done to you when you are defending yourself against their lawsuit, specifically defamation. Moreover, by choosing to bring their claims under California law, the Wayfarer parties have voluntarily subjected their entire lawsuit to the SH privilege in the recently enacted California Civil Code 47.1. We'll hear more about that later, which bars retaliatory lawsuits based on public disclosures of harassment and related allegations, including disclosures to the press, which makes sense, right? Every famous person that was ever accused of something like this, and unfortunately it's happening more and more. The fortunate part is at least people feel like they have the power and ability to do this, but they didn't want big celebrities to be able to sue them and say, that's a lie, defamation, extortion, you're trying to get money out of me, so I'm going to sue you. But there are, of course, protections in place for those who are wrongfully accused. If the victim knowingly, wrongfully accuses you of this type of harassment. So you're seeing where there's somewhat of a factual question here. Given all these protections, the Wayfarer party's chief complaint that Miss Lively and others supposedly conspired with the New York Times is barred as a matter of law. she was legally entitled to file her complaint and disclose it to the public. So once again, she's not even trying to argue they didn't disclose to the public, right? Not trying to save face. They don't care what the public thinks of them as far as this goes with this situation. They're saying, even if that's all true and we disclosed it to the public after we filed it, it's protected. On top of that, Section 47.1 contains a mandatory fee shifting provision that will require the Wayfair parties to pay not only Ms. Lively's attorney's fees, but also treble damages and punitive damages if and when their defamation lawsuit is dismissed. So fee shifting means you have to pay the other side's fees if you lose under this 47.1. Treble damages means 3 times your damages, which if you get $1 million, that means 3 million, plus punitive damages to punish you as the defendant if you violate California Civil Code Section 47.1. So that's a big deal by invoking that. But also, it's a big deal for people that make that kind of claim, make that kind of harassment claim, because they know that protection exists, which makes it even harder for defendants who are wrongfully accused to come out and legally fight for themselves. But there are 2 ways you can fight it if you're a defendant like Justin Baldoni. Number 1, you can fight it by defending yourself vigorously against those harassment claims. Or you can go on the offensive and file complaints like Baldoni did. And when you go on the offensive, you open yourself up to this potential risk. So here she goes with some snark here. In other words, in an epic self-own, the Wayfair parties have created more liability for themselves by their malicious efforts to sue Blake Lively into oblivion. We've heard those words before, right? Steve Sarowitz may indeed make good on his threat to spend $100 million litigating against Ms. Lively, but perhaps not in the way he planned. So he said, I'll pay these lawyers to defend our rights and to prosecute what we think she did wrong. But Blake Lively's like, no. You're going to end up giving me that money when I prove you have to pay my fees, triple the damages, and punitive damages. Only time will tell. Among its many additional incurable defects, the First Amendment complaint, every time you see FAC, F-A-C, it's First Amendment complaint that Baldoni, the Wayfair parties filed, does not allege a single element of the defamation or false light claims properly, starting with the failure to allege defamatory statements with specificity, instead lumping all plaintiffs' claims together as an impermissible group pleading. If that is found to be true and the court dismisses it because of that, they're going to give them the opportunity to refile and be dismissed without prejudice. Brushing aside this obvious problem, the Wayfair parties have repeatedly asserted in recent filings that their claims against all the consolidated defendants, including Ms. Lively, arise from 2 principal categories of defamatory statements. Allegations, number 1, allegations that Baldoni and Heath engaged in sexual misconduct toward Ms. Lively. And number 2, allegations that the Wayfair parties orchestrated a retaliatory smear campaign to damage Lively's image and reputation after she reported their purported misconduct. So it's important because there's 2 categories. Only one invokes Section 47.1, which is the harassment or misconduct claim. And it's important to keep those separate because Lively, I think, sometimes in this motion to dismiss lumps them together because she feels like she has a stronger argument with the harassment claims. This admission is fatal to their claims, as these 2 principal categories make clear. The only alleged wrongdoing the FAC attributes to Ms. Lively stems from her speaking up about harassment and retaliation, which is firmly protected by each of the litigation, fair report, and harassment privileges. In any event, the bulk of the Wayfair parties' reputation-based claims are time-barred because the FAC expressly admits that Ms. Lively first published her her allegedly defamatory sexual harassment allegations in her 17-point list in November of 23. More than 1 year before Wayfair initiated this action, and thus outside the 1-year statute of limitations. We'll talk about that when we get there. And as for their menacing $400 million damages claim, they don't even try to explain it, much less specifically allege their so-called injuries. Yet another of the FAC's insurmountable deficiencies is its utter failure to allege actual malice. This is the biggest part of the entire motion to dismiss, complaint, allegation. Same thing in Johnny Depp's case, proving actual malice. Of course, they're public figures. Ms. Lively, i.e., that Ms. Lively subjectively did not believe the SH allegations she raised. This, in my opinion, is what I was saying Amber Heard should have done from the jump. You can't prove that I didn't, at least in my brain, subjectively believe this. Now, maybe I was wrong. Maybe a jury would not agree with me, and therefore I would lose my harassment claim, which is fine. Again, that's the defense Baldoni could mount against the harassment claim. Blake Lively could be absolutely wrong in how she sees the facts, and that's basically what she's saying here. But as long as she objectively means it's the truth. Everybody sees it the same way. Subjectively is what we believe in our mind. Does she believe these claims to be true? And if she does, you can't get defamation because it's not actual malice because he's a public figure. And that always is what I felt like was Amber Heard's best argument. She never really went there. She went on the offensive to talk about how horrible of a guy Johnny Depp is and how she never did anything wrong in the marriage and things like that. Other than many pages of empty bluster, more snark, the FAC not only fails to allege actual malice, it pleads just the opposite by demonstrating her good faith beliefs. Now, obviously, this is lawyer speak. This is how they see it. This is reading a motion from one side. She's like, oh, he even admits that we had a good faith basis. Of course, that's not what he actually does, but they use some of his language against it. Among other things, the FAC incorporates by reference a damning text message between Baldoni and Nathan in which both agree that Miss Lively genuinely believes she's right and that all of this is unjust. Again, they clearly are saying in that text, she's dead wrong. How could she possibly think this? This is so obvious, but that she subjectively, genuinely believes what she's saying is right. They say that's an admission the FAC can't overcome. In lieu of concrete facts, the FAC resorts to implausible conjecture and conspiracy theories to allege that Miss Lively falsified her allegations. On the one hand, the Wayfarer parties insist that Miss Lively is an immensely powerful Hollywood superstar who, along with her influential husband, wielded power to steal creative control over the film. But on the other hand, they claim she was so powerless that the only way she could have the power was by manufacturing these harassment allegations almost a year in advance in a Machiavellian long game. I kind of like that argument, legally speaking, right? Factually, we're not even discussing whether a jury is going to look at that harassment claim, look at the B-roll footage, look at the text message, never with teeth or whatever it is, and say, yeah, right, she was not harassed. That could very well be true, and they could still win this motion. Because what her lawyer is saying is your argument doesn't make sense. She's the biggest, most powerful superstar in the world, but that she also had to make up these harassment claims. Even you knew what she said. She actually believed it. Whether she was right or wrong, she believed it. These two concepts contradict each other and therefore cannot coexist. Even if these bizarre theories made sense, which they do not, the FAC offers no plausible facts to support the conclusory assertion that Miss Lively either subjectively doubted that any of the misconduct she alleged had occurred as she described it, including the 17-point list, the disclosures made January 4th, or her eventual legal complaints. Indeed, despite its narrative fury against her, the FAC repeatedly and consistently includes facts that demonstrate Miss Lively's genuine good faith belief that she was mistreated and her appropriate and private efforts to improve the situation for herself and others. So again, you can be dead wrong, objectively. A jury can disagree with you, but subjectively, it still matters in certain circumstances like this. But there's still a very big kicker coming. There's a very big argument coming in a very big situation where this is one side explaining the way they would argue it. As for the FAC's other claims, it is unclear whether a civil extortion claim exists under California law, but even if it does, the nature of the alleged extortion is so convoluted that it cannot survive. The so-called extortion arises out of the exact same categories of protected speech that fail to support defamation. Ms. Lively's supposed threats to reveal her harassment claims if the Wayfarer party did not give her demands for creative control of the movie, threats which are never specifically identified anywhere in the FAC because they never happened. Moreover, the FAC does not allege what money or property Lively received from Wayfair for supposedly extorting her way into editing a movie for no additional pay. And again, this is where they kind of just make these conclusory statements that it can't go forward, it's not going to win, and we're not going to dig in as much to these claims. Indeed, the FAC's self-defeating claim appears to be that Ms. Lively bullied her way into doing more work than she was contractually obligated to do, without additional compensation, while Wayfair profited handsomely from the movie's blockbuster success. Notably, the Wayfair parties did not pursue any action against Lively for supposed extortion till after she filed legal claims, which speaks volumes to this lawsuit's purposes. Again, that's not a great legal argument, but factually speaking, she's trying to make the judge say, oh yeah, I guess that makes sense. If it was real, they would have filed it. Why did they wait until after she filed? Or to a jury one day. The FAC also claims that Ms. Lively violated the implied covenant of good faith and fair dealing, but cannot identify any term upon which that duty hinges. As with above, this claim seems to be based on Ms. Lively doing more than was contractually required rather than a breach of any obligation. Finally, the Wayfair parties claim Ms. Lively interfered with the contract, yet unable to identify the contract, any of its terms, who it was with, or how it was breached. In short, nothing in the FAC resembles an actionable legal claim. It is instead a blunt public relations instrument designed to further the Wayfair party's sinister campaign to bury and destroy Ms. Lively for speaking out about harassment and retaliation. The court should dismiss the FAC as required by California law, hold further proceedings to calculate an appropriate award for Ms. Lively's attorney's fees, treble damages for the harm of this meritless lawsuit has inflicted on her, and punitive damages against each of the Wayfair parties. It's coming out swinging. Then we get to the background section where basically they just go through how the first amended complaint is all lies. They go through the fact that they admit the 17 points are true, but they just quibble with some of the characteristics or the details on it. The subjectivity there is big. They talk about how she tried to do this privately and before she did it publicly, which doesn't line up with a lot of their claims either. And she took legal action, which is protected. I do want to read here the legal standard. In reviewing a motion to dismiss under Federal Rule of Civil Procedure 12b-6, the court accepts all factual allegations as true and draws all reasonable inferences in plaintiff's favor. That means, and we've talked about it already in this case, and people got upset that I was reading one complaint or the other as if everything in this complaint is true, but that's exactly the legal standard. When the judge reads Baldoni's complaint, he has to read it as if it were true. A jury might not agree with him one day, but if it's true, can he prove these claims? And if everything he said is true and he still can't win because of privilege or other things, dismiss it. But if it's all true and he can win, you got to let it ride. The requirement is inapplicable to legal conclusions. A complaint must offer more than labels and conclusions or a formulaic recitation of the elements of a cause of action or naked assertions devoid of further factual enhancement in order to survive dismissal. All right. Next, I am going to get to page 12 here. All right. The Wayfair parties failed to meet basic pleading requirements to identify specific defamatory statements. As a preliminary matter, the defamation claims must be dismissed based on Wayfair parties' utter failure to plead any allegedly defamatory statements with specificity. To survive dismissal, the disparagement set forth in the complaint must be sufficiently close to the actual words, proved to acquaint a defendant with what he must defend against. You have to tell them what you're suing them for so they can defend against it. A long line of cases in this district holds that a defamation claim is only sufficient if it adequately identifies the purported communication and an indication of who made the communication, when it was made, and to whom it was communicated. Even under liberal federal pleading standards, general allegations of defamatory statements which do not identify the substance of what was said are insufficient. If you remember, in the Amber Heard situation, they had to pick out what specific parts of the article were defamatory. They cite other cases that say dismisses complaints when the plaintiff failed to identify and state the substance of the allegedly defamatory statement, the general rule of which is that the words constituting an alleged libel must be specifically identified if not pleaded verbatim. Even for slander, a plaintiff must plead with specificity, particularly to give notice of the issues and enable the defendants to prepare a defense. As set forth in the FAC or above, the FAC does not assert a single defamatory statement attributable to Ms. Lively. Instead, it identifies two categories of defamation that are entirely contained within the four corners of the legal complaints. Yet, nowhere do the Wayfarer parties explain which of the 8 plaintiffs in this action was allegedly defamed, identify any purported defamatory statement made by Lively, or otherwise identify any false allegation asserted by her that supports their defamation claim, leaving Ms. Lively to guess at what to defend against. That's important, but if Baldoni loses, he's going to be able to refile if he loses because of this. Okay, next is a statute of limitations argument, which was an interesting one. That the initial 17-point bullet list happened before January 17, 24. The initial complaint filed by Baldoni was January 16, 25. So they would be barred by the 1-year statute of limitations. And they argue that when it's first published is when the statute of limitations starts. But things can be republished, and if it's the same exact publication, then that can be true. But if it's a new defamatory statement or a new publication of similar statements or even the same statement, sometimes the statute of limitation can reset. So this is going to be one Baldoni's going to have to argue. Baldoni's going to have to put out there specifically, these are the defamatory statements. This is when it happened. This is the damage they caused. He may have to refile and get more specific with some of his claims. That is possible. All right. Now let's get to some of the best arguments made by Lively and her team. And that is that these statements that she made, that she believes, and again, it's kind of interesting to argue on one side, you don't know what he said the defamatory statements are. Then on the other side, argue these statements he says are defamatory are protected. Sounds like you might know what some of the statements are, but we'll see how Baldoni responds. And he may have already responded by the time you're listening to this. But these are very good arguments. So first, are the statements Baldoni says are defamatory protected? Are they privileged? Can you not get sued for them? We're going to talk about 3 different categories. But this is also important for Baldoni's team if he wants to amend his complaint to make sure the statements don't fall into any of these privileges, or to make sure he has arguments to combat these privileges. Two separate and absolute privileges bar the claim. The fair report privilege. The FAC accuses Ms. Lively of leaking the CRD complaint to the Times. Which, even if it was true, and again, they almost admitted it was true in the summary, but even if it's true, it's protected by the fair report privilege, a definitive and separate bar to the defamation claim. The fair report privilege shields liability arising from a communication to a public journal of a judicial, legislative, or other public official proceeding, or of anything said in the course thereof. This privilege is absolute and construed broadly. When, as here, the fair report privilege applies, it is absolute, and we have no occasion to consider the defendant's motives or whether the statements were uttered with malice. And importantly, it applies to complaints to government agencies requesting that the agency investigate or remedy wrongdoing. Although the fair report privilege is typically invoked by news media defendants, it also protects those who communicate information to the media, including those who deliver copies of official documents to the news outlet. So she's saying, I'm not saying I did this, but if I did it, it's protected. Indeed, the legislation amended Section 47, abrogating a prior ruling that an attorney's transmittal of a copy of a pleading to the newspaper was not protected by the fair report privilege. That amendment created the bridge between the litigation privilege, which covered the statements made in the judicial proceeding, and the fair report privilege, which covered the media reports of judicial proceedings, to protect a third party who communicates this already privileged material to the press. Thus, fair and true communications to the news media about allegations in a complaint are covered by privilege. Now, here's the second privilege, the litigation privilege. Ms. Lively's alleged statements, wholly contained within the legal complaints, are further absolutely protected by the litigation privilege, which protects publications in any legislative, judicial, or other proceedings. Statements made in an EEOC complaint were privileged and could not be used to establish liability in a defamation action, even if they were made maliciously. So isn't that interesting? Even if they were made maliciously. Critically, this privilege attaches even before official proceedings are initiated, where a good faith and serious contemplation of litigation exists. A pre-lit communication is privileged only when it relates to litigation that is contemplated in good faith. The litigation privilege is designed to afford litigants and witnesses the utmost freedom of access to the courts without fear of retribution through subsequent tort actions. I can't tell you how many clients or friends or people have called me saying, can I sue this guy for suing me? Emotional distress. He's making me miserable just because he sued me. The answer is no. This is why. Litigation privilege. Here, there is no question the privilege applies to both the CRD complaint and the SDNY complaint. Ms. Lively submitted the CRD complaint to the state agency charged with investigating and rectifying harassment and retaliation, as she's legally required to do, which clearly states, this rule states, a publication in the course of a judicial proceeding. The Wayfair parties assert, based solely on their purported belief that Ms. Lively never intended to file her CRD complaint in federal court, a prediction that is legally irrelevant and that was disproven when she did just that. More importantly, it's almost like you won't, but she did it. The privilege protects Lively's administrative complaint regardless of her intent to initiate additional subsequent civil litigation. But again, it's a moot point because she did file it. California law protects the bridge between the privileges. Whereas here, the legal complaints and the Times publications are absolutely privileged, it would defeat the purpose of Section 47 to punish transmittal of the privilege pleading to the press. The same outcome is warranted here. It would be anomalous to hold that a litigant is privileged to make publication necessary to bring an action, but that he can be sued for defamation if he lets anyone know that he has brought it. This was made for California, right? It just invites lawyers to send their complaints out to the press, which many do. And the power of the press and the power of public perception and publicity can be very important, especially to fight injustice and to fight an imbalance of power. The Wayfarer parties attempted to avoid these absolute privileges by speculating that Ms. Lively delivered to and discussed her CRD complaint with the Times before filing it. But even if it's true, that would not constitute a waiver of her privileges. As explained by Abraham, such a holding would defeat the purpose of the privileges under Section 47. Next, California's harassment privilege immunizes Ms. Lively from liability. So this is the big one. Ms. Lively's statements about the harassment she experienced on set and the subsequent retaliation campaign waged against her, whether made in legal filings, to the press, or to any other third party before or after filing the complaint, fall squarely within the new statutory privilege of California Civil Code 47.1. The privilege provides that communications made by an individual without malice, that's important, regarding an incident of harassment, assault, discrimination, are privileged. Also, the mandatory fee shifting, punitives, treble damages. California enacted Section 47.1 to clarify and codify existing law in direct response to the repeated attacks upon individuals who report this type of harassment, and to provide a strong remedy to disincentivize retaliatory litigation, to curb a pervasive culture of assault and harassment. So we wanted to get rid of the fact that you could sue somebody just because they accused you of this type of harassment, and provide significant remedies for successful defendants in defamation cases, and to make dang sure they're sure before they file, because they could get punitive damages, fees, treble damages. It was necessary. The legislature explained that Section 47.1 was necessary because, while positive, the Me Too movement also unveiled a predatory culture that persists across all sectors of employment and society, in which many victims have been served with defamation lawsuits. The legislator went on to describe these retaliatory suits as a weapon to threaten, silence, intimidate, and dissuade their accusers. So you can understand it's coming from a good place. But it also weaponizes false accusations, because you can falsely accuse, and if they can't prove it, it can be a very hard thing to do with somebody, to prove what somebody subjectively believes. But if you can't prove it, now you got to pay my fees, treble damages, punitive damages, just for filing this lawsuit to protect yourself against false accusations. That's why that without malice language, and we're seeing so much about malice that we're going to hit in the next section. To curb this, 47.1 provides immunity against claims seeking to hold individuals liable. Okay. Whether in a legal proceeding, the press, or otherwise, to cover communication, the act of the harassment by a director or producer, an act of workplace harassment or discrimination, failure to prevent an act of workplace harassment or discrimination, aiding, abetting, inciting, compelling, coercing an act of workplace harassment or discrimination, or an act of retaliation against a person for reporting or opposing workplace harassment. No doubt about it, these all fall within that new rule. To be protected, the speaker need only have, or at any time, had a reasonable basis to file a complaint of assault, harassment, discrimination, whether the complaint is or was filed or not. So the pendulum always swings. People were getting away with this. The Hollywood culture, the workplace culture was so bad. We need to protect these victims. But now, has it swung too far the other direction where nobody gets in trouble for false accusations? We saw Diddy come out, very publicly fight against it, and allegedly win, to where allegedly the victim recanted. What is going to be the punishment there? Baldoni is accusing Blake Lively of the same thing. You're lying on me. It's not true. So what protections does he have? What can he do if not sue her for defamation? And if he didn't have a huge financial backer, would this statute scare him too much? How many defendants does it scare too much? Because they don't have the financial backing. Writing laws and coming up with laws in the justice system is very difficult. You're constantly battling a swinging pendulum with society. What's right? What has become a systemic problem? What do we need to fix? What do we not need to fix, right? We don't want to create more laws just to create more laws, because that creates weaponizing certain laws. As explained by the California legislature, the protections would apply to individuals who, after relaying any factual statement, whether in the form of a formal complaint or a statement outside of a formal proceeding, such as to the media outlet, are sued for defamation. Indeed, the statute was enacted in large part to address defamation claims filed against harassment victims based upon statements made to the press. She says it plainly applies to the Wayfarer parties here. I tend to agree that it would apply. But now we get to actual malice, which to me is the biggest hook of all, and what Baldoni is setting out to prove and to take on this battle, take on this fight. He's taking on parts of what Amber Heard had to do and parts of what Johnny Depp had to do. And I'll explain it here. But we get into actual malice because he is a public figure. And on page 22 here, it says, the actual malice standard is focused on the subjective attitude of the publisher, and therefore requires the first amended complaint to plead facts demonstrating that Miss Lively's statements were made with knowledge that it was false, or with reckless disregard of whether it was false or not. So while that is a crazy high standard, like, how do you prove that? How do you prove that? And that's something Johnny Depp had to do, basically. Taking on the battle, the very difficult way or cause to win on defamation. Talked about it ad nauseum. I'm sure we're going to talk about it again as this case progresses. But if he can prove it, that it was made with malice, that Blake Lively did, in fact, know that those statements were false, or did she recklessly disregard whether or not they were false or not? Because if he can prove it, this entire motion to dismiss crumbles. If he can prove she lied, she knew she lied, she didn't feel harassed, she didn't feel retaliated against, she knew it was because of her own bad interviews or she was trying to take over the movie or whatever the allegations are in Baldoni's complaint, if they're true, I think they do prove actual malice. Will the judge have to, make him move stuff around or refile certain things and grant parts of this motion to dismiss? Maybe. But I think at the end of the day, and he'll have to deal with the statute of limitations issue to determine specifically what was said when. I didn't go back and check every single one of those dates. I'm sure one of you guys will. But if everything he says in his complaint is true, which is that she knows that's false and still said it for other motives, then can he get over the actual malice bar? And I think he can if it's true, right? Proving to a jury is another entirely different scenario. But getting past the motion to dismiss, you just have to plead something that if it's true, you win. It is well established that satisfying the actual malice standard requires more than bald recitation of the words malicious or maliciously, nor is it sufficient to assert that a defendant knew the statements were false or had serious doubts about the truth of the statements. The conclusory boilerplate allegation that the defendant acted maliciously and oppressively and in conscious disregard of plaintiff's rights is insufficient to state a cause of action. So again, if he loses on this point, I do believe they will be able to refile and add in enough language to get past this actual malice scenario. Lively goes on to say they can't prove that she lied ever or that she even doubted the truthfulness of her allegations. And again, like I said, I think that's what Amber Heard should have gone with. They can try to assign different motives, but they never say she lied. That's what Lively argues. And they also say, again, why would she continuously report this stuff privately if this was all done for a public show to lie and get what she wanted? Then here on page 24. Under section 48A, actual malice is defined as a state of mind arising from hatred or ill will towards the plaintiff. However, the section further clarifies that a good faith belief on the part of the defendant in the truth of the libelous publication or broadcast at the time it was published or broadcast shall not constitute actual malice. So even if you figure out later that what you said was not true, if you believed it at the time you said it, that's what matters. The Wayfarer party's own admissions, therefore, demonstrate the absence of actual malice. It's a good motion to dismiss, in my opinion. It's a really well done motion to dismiss. So the rest of the claims, again, they argue failed to state a cause of action, don't state damages, failed pleading requirements, threats of legal action or not distortion, those kind of arguments. We're not going to dive into those as much today, but I did want to hit this legal fees provision. As the prevailing party, Ms. Lively is entitled to her attorney's fees and damages under section 47.1, which provides a prevailing defendant shall. So these are statutory fees. You shall win fees if you win for successfully defending themselves in the litigation, plus treble damages for any harm caused. So what harm did those lawsuits cause? If Baldoni loses the defamation case, what harm did he cause by filing it? In addition to punitive damages under section 3294 or any other relief otherwise permitted by law. For the reasons discussed above, the Wayfarer party's defamation claims fail as a matter of law. Having successfully defended these claims, Ms. Lively is a prevailing party and under the statute and is entitled to a reasonable attorney's fees and costs. So if she wins this motion to dismiss, if the entire case for defamation goes away, under 47.1, Baldoni et al. Will have to pay her a lot of money. I think the chances of the case completely going away and getting dismissed based on this motion to dismiss are very slim. I think there were some great arguments made, but I don't think that it's going to completely go away without at least one other opportunity for Baldoni and his team to file another amended complaint. Could be wrong. The judge could see it and say, absolutely privileged, you lose, pay her fees. The judge could say, these are barred by the statute of limitations. By the way, something that's barred for the statute of limitations, I'd have to look because we don't have something like 47.1 that I'm aware of. So if it's barred by the statute of limitations and not because it's protected under 47.1, I don't think she would be entitled to the statutory fees and costs. I'd have to look that up, though. That's an interesting concept. If you win, but not for this reason, usually you don't get the remedies that this reason provides you if you win for this reason. But I can't wait to hear what you guys think. What do you think? Good arguments made, bad arguments made? Let me know in the comments. Let me know if you're interested in this case by hitting the like button. There's a lot I'm reading up on and catching up on, and I plan to do some videos over the next couple weeks on this case. If you guys are interested, of course, let me know. But for now, that's all we got. Until next time, I am out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the Lawyer You Know.